Province of North Cotabato et al. Versus Republic of the Philippines et al. Decision. Carpio-Morales, J. Subject of these consolidated cases is the extent of the powers of the President in pursuing the peace process. While the facts surrounding this controversy center on the armed conflict in Mindanao between the government and the Moro Islamic Liberation Front, MILF, the legal issue involved has a bearing on all areas in the country where there has been a long-standing armed conflict. Yet again, the court is tasked to perform a delicate balancing act. It must uncompromisingly delineate the bounds within which the President may lawfully exercise her discretion, but it must do so in strict adherence to the Constitution, lest its ruling unduly restricts the freedom of action vested by that same Constitution in the Chief Executive precisely to enable her to pursue the peace process effectively. Factual antecedents of the petitions. On August 5, 2008, the Government of the Republic of the Philippines, GRP, and the MILF, through the chairpersons of their respective peace negotiating panels, were scheduled to sign a Memorandum of Agreement on the Ancestral Domain, MOAD, aspect of the GRP-MILF Tripoli Agreement on Peace of 2001 in Kuala Lumpur, Malaysia. The MILF is a rebel group which was established in March 1984 when, under the leadership of the late Salamat Hashim, it splintered from the Moro National Liberation Front, MNLF, then headed by Nur Miswari, on the ground, among others, of what Salamat perceived to be the manipulation of the MNLF away from an Islamic basis towards Marxist-Maoist orientations. 1-1. The signing of the MOAD between the GRP and the MILF was not to materialize, however, for upon motion of petitioners, specifically those who filed their cases before the scheduled signing of the MOAD, this court issued a temporary restraining order enjoining the GRP from signing the same. The MOAD was preceded by a long process of negotiation and the concluding of several prior agreements between the two parties beginning in 1996, when the GRP-MILF peace negotiations began. On July 18, 1997, the GRP and MILF peace panels signed the Agreement on General Cessation of Hostilities. The following year, they signed the General Framework of Agreement of Intent on August 27, 1998. The Solicitor General, who represents respondents, summarizes the MOAD by stating that the same contained, among others, the commitment of the parties to pursue peace negotiations, protect and respect human rights, negotiate with sincerity in the resolution and pacific settlement of the conflict, and refrain from the use of threat or force to attain undue advantage while the peace negotiations on the substantive agenda are ongoing. 2-2. Early on, however, it was evident that there was not going to be any smooth sailing in the GRP-MILF peace process. Towards the end of 1999 up to early 2000, the MILF attacked a number of municipalities in central Mindanao and, in March 2000, it took control of the town hall of Coswagan, Lanao del Norte. 3-3. In response, then-President Joseph Estrada declared and carried out an all-out war against the MILF. When President Gloria Macapagal-Arroyo assumed office, the military offensive against the MILF was suspended and the government sought a resumption of the peace talks. The MILF, according to a leading MILF member, initially responded with deep reservation, but when President Arroyo asked the government of Malaysia through Prime Minister Mahathir Mohamad to help convince the MILF to return to the negotiating table, the MILF convened its Central Committee to seriously discuss the matter and, eventually, decided to meet with the GRP. 4-4. The parties met in Kuala Lumpur on March 24, 2001, with the talks being facilitated by the Malaysian government, the parties signing on the same date the agreement on the general framework for the resumption of peace talks between the GRP and the MILF. The MILF thereafter suspended all its military actions. 5-5. Formal peace talks between the parties were held in Tripoli, Libya from June 20 to 22, 2001, the outcome of which was the GRP-MILF Tripoli Agreement on Peace, Tripoli Agreement 2001, containing the basic principles and agenda on the following aspects of the negotiation: security aspect, rehabilitation aspect, and ancestral domain aspect. With regard to the ancestral domain aspect, The parties in Tripoli Agreement 2001 simply agreed that the same be discussed further by the parties in their next meeting. A second round of peace talks was held in Cyberjaya, Malaysia on August 5–7, 2001, which ended with the signing of the implementing guidelines on the security aspects of the Tripoli Agreement 2001, leading to a ceasefire status between the parties. This was followed by the implementing guidelines on the humanitarian rehabilitation and development aspects of the Tripoli Agreement 2001, which was signed on May 7, 2002 at Putrajaya, Malaysia. Nonetheless, there were many incidents of violence between government forces and the MILF from 2002 to 2003. Meanwhile, then MILF chairman Salamat Hashim passed away on July 13, 2003, and he was replaced by Al-Haj Murad, who was then the chief peace negotiator of the MILF. Murad's position as chief peace negotiator was taken over by Mohagar Iqbal. 6-6. In 2005, several exploratory talks were held between the parties in Kuala Lumpur, eventually leading to the crafting of the draft MOAD in its final form, which, as mentioned, was set to be signed last August 5, 2008. 2. Statement of the proceedings. Before the court is what is perhaps the most contentious consensus ever embodied in an instrument, the MOAD, which is assailed principally by the present petitions bearing docket numbers 183,591, 183,752, 183,893, 183,951 and 183,962. Commonly impleaded as respondents are the GRP Peace Panel on Ancestral Domain 77, and the Presidential Advisor on the Peace Process, PAPP, Hermogenes Esperon Jr. On July 23, 2008, the province of North Cotabato 88, and Vice Governor Emmanuel Pinol filed a petition, docketed as GR number 183,591. For mandamus and prohibition, with prayer for the issuance of writ of preliminary injunction and temporary restraining order. 99. Invoking the right to information on matters of public concern, petitioners seek to compel respondents to disclose and furnish them the complete and official copies of the MOAD including its attachments, and to prohibit the slated signing of the MOAD, pending the disclosure of the contents of the MOAD and the holding of a public consultation thereon. Supplementarily, petitioners pray that the MOAD be declared unconstitutional. 1010. This initial petition was followed by another one, docketed as GR number 183,752, also for mandamus and prohibition 1111, filed by the city of Zamboanga, 1212, Mayor Celso Law Brigat, Rep. Ma. Isabel Climaco and Representative Erico Basilio Fabian, who likewise pray for similar injunctive reliefs. Petitioners herein moreover pray that the city of Zamboanga be excluded from the Bangsamoro homeland and or Bangsamoro juridical entity and, in the alternative, that the MOAD be declared null and void. By resolution of August 4, 2008, the court issued a temporary restraining order commanding and directing public respondents and their agents to cease and desist from formally signing the MOAD. 1313. The court also required the Solicitor General to submit to the court and petitioners the official copy of the final draft of the MOAD, 1414, to which she complied. 1515. Meanwhile, the city of Iligan 1616, filed a petition for injunction and or declaratory relief, docketed as GR number 183,893, praying that respondents be enjoined from signing the MOAD or, if the same had already been signed, from implementing the same, and that the MOAD be declared unconstitutional. Petitioners herein additionally implead Executive Secretary Eduardo Ermita as respondent. The Province of Zamboanga del Norte, 1717, Governor Orlando Yepes, Vice Governor Francis Alves, Representative Cecilia Gilas Jose Carreon, Representative Cesar Gilas Jose, and the members 1818, of the Sangguniang Panlalagan of Zamboanga del Norte filed on August 15, 2008 a petition for certiorari, mandamus, and prohibition, 1919, docketed as GR number 183,951. They pray, inter alia, that the MOAD be declared null and void and without operative effect, and that respondents be enjoined from executing the MOAD. On August 19, 2008, Ernesto Maceda, Jajomar Binay, and Aquilino Pimentel III filed a petition for prohibition, 2020, docketed as GR number 183962, praying for a judgment prohibiting and permanently enjoining respondents from formally signing and executing the MOAD and/or any other agreement derived therefrom or similar thereto, and nullifying the MOAD for being unconstitutional and illegal. Petitioners herein additionally implead as respondent the MILF Peace Negotiating Panel represented by its chairman Mohagar Iqbal. Various parties moved to intervene and were granted leave of court to file their petitions/comments in intervention. Petitioners in intervention include Senator Manuel A. Roxas, former Senate President Franklin Drilon and Attorney Adelto Mano, the City of Isabela 2121, and Mayor Cherlyn Santos Akbar, the Province of Sultan Kudarat 2222, and Governor Suharto Mangudadatu, the Municipality of Linamon in Lanao del Norte, 2323, Rui Elias Lopez of Davao City and of the Bagobo Tribe, Sangguniang Panlungsod member Marino Ridao and businessman Kaisen Buxani, both of Cotabato City, and lawyers Carlo Gomez, Gerardo Dilig, Nazario Awat, Joselito Alajuag, Rich Alex Jagmas, all of Palawan City. The Muslim Legal Assistance Foundation Incorporated, MUSLOF, and the Muslim Multi-Sectoral Movement for Peace and Development, MMMPD, filed their respective comments and intervention. By subsequent resolutions, the court ordered the consolidation of the petitions. Respondents filed comments on the petitions, while some of petitioners submitted their respective replies. Respondents, by manifestation and motion of August 19, 2008, stated that the Executive Department shall thoroughly review the MOAD and pursue further negotiations to address the issues hurled against it, and thus moved to dismiss the cases. In the succeeding exchange of pleadings, respondents' motion was met with vigorous opposition from petitioners. The cases were heard on oral argument on August 15, 22 and 29, 2008 that tackled the following principal issues. 1. Whether the petitions have become moot and academic. Insofar as the mandamus aspect is concerned, in view of the disclosure of official copies of the final draft of the Memorandum of Agreement, MOA, and 2. Insofar as the prohibition aspect involving the local government units is concerned, if it is considered that consultation has become fait accompli with the finalization of the draft. 2. Whether the constitutionality and the legality of the MOA is ripe for adjudication. 3. Whether respondent government of the Republic of the Philippines Peace Panel committed grave abuse of discretion amounting to lack or excessive jurisdiction when it negotiated and initiated the MOA vis-a-vis issues Nos. 4 and 5. 4. Whether there is a violation of the people's right to information on matters of public concern, 1987 Constitution, Article 3, Sec. 7, under a state policy of full disclosure of all its transactions involving public interest, 1987 Constitution, Article 2, Sec. 28, including public consultation under Republic Act No. 7160, Local Government Code of 1991. If it is in the affirmative, whether prohibition under Rule 65 of the 1997 Rules of Civil Procedure is an appropriate remedy. 5. Whether by signing the MOA, the government of the Republic of the Philippines would be binding itself. A. To create and recognize the Bangsamoro Juridical Entity, BJE, as a separate state, or a juridical, territorial or political subdivision not recognized by law. B. To revise or amend the Constitution and existing laws to conform to the MOA. C. To concede to or recognize the claim of the Moro Islamic Liberation Front for ancestral domain in violation of Republic Act No. 8371, the Indigenous Peoples' Rights Act of 1997, particularly Section 3G and Chapter 7, Delineation, Recognition of Ancestral Domains. If in the affirmative, whether the executive branch has the authority to so bind the government of the Republic of the Philippines. 6. Whether the exclusion of the province of North Cotabato, cities of Zamboanga, Iligan, and Isabela, and the municipality of Linamon, Lanao del Norte from the areas covered by the projected Bangsamoro homeland is a justiciable question, and 7. Whether desistance from signing the MO derogates any prior valid commitments of the government of the Republic of the Philippines. 2424. The court, thereafter, ordered the parties to submit their respective memoranda. Most of the parties submitted their memoranda on time. 3. Overview of the MOAD. As a necessary backdrop to the consideration of the objections raised in the subject 5 petitions and 6 petitions in intervention against the MOAD, as well as the 2 comments in intervention in favor of the MOAD, the court takes an overview of the MO. The MOAD identifies the parties to it as the GRP and the MILF. Under the heading Terms of Reference, TOR, the MOAD includes not only 4 earlier agreements between the GRP and MILF, but also 2 agreements between the GRP and the MNLF, the 1976 Tripoli Agreement, and the final peace agreement on the implementation of the 1976 Tripoli Agreement, signed on September 2, 1996 during the administration of President Fidel Ramos. The MOAD also identifies as TOR 2 local statutes, the Organic Act for the Autonomous Region in Muslim Mindanao, ARMM 2525, and the Indigenous Peoples' Rights Act, IPRA, 2626, and several international law instruments, the ILO Convention No. 169 concerning indigenous and tribal peoples in independent countries in relation to the UN Declaration on the Rights of the Indigenous Peoples, and the UN Charter, among others. The MOAD includes as a final TOR the generic category of compact rights entrenchment emanating from the regime of Dar el-Mu'ahada, or territory under compact, and Dar el-Sul, or territory under peace agreement, that partakes the nature of a treaty device. During the height of the Muslim Empire, early Muslim jurists tended to see the world through a simple dichotomy. There was the Dar el-Islam, the abode of Islam, and Dar el-Harb, the abode of war. The first referred to those lands where Islamic laws held sway, while the second denoted those lands where Muslims were persecuted or where Muslim laws were outlawed or ineffective. 2727. This way of viewing the world, however, became more complex through the centuries as the Islamic world became part of the international community of nations. As Muslim states entered into treaties with their neighbors, even with distant states and intergovernmental organizations, the classical division of the world into Dar el-Islam and Dar el-Harb eventually lost its meaning. New terms were drawn up to describe novel ways of perceiving non-Muslim territories. For instance, areas like Dar el-Mu'ahada, land of compact, and Dar el-Sul, land of treaty, referred to countries which, though under a secular regime, maintained peaceful and cooperative relations with Muslim states, having been bound to each other by treaty or agreement. Dar el-Aman, land of order, on the other hand, referred to countries which, though not bound by treaty with Muslim states, maintained freedom of religion for Muslims. 2828. It thus appears that the compact rights entrenchment emanating from the regime of Dar el-Mu'ahada and Dar el-Sul simply refers to all other agreements between the MILF and the Philippine government, the Philippines being the land of compact and peace agreement, that partake of the nature of a treaty device, treaty being broadly defined as any solemn agreement in writing that sets out understandings, obligations, and benefits for both parties, which provides for a framework that elaborates the principles declared in the MOAD. 2929. The MOAD states that the parties have agreed and acknowledged as follows, and starts with its main body. The main body of the MOAD is divided into 4 strands, namely, concepts and principles, territory, resources, and governance. A. Concepts and principles. This strand begins with the statement that it is the birthright of all Moros and all indigenous peoples of Mindanao to identify themselves and be accepted as Bangsamoros. It defines Bangsamoro people as the natives or original inhabitants of Mindanao and its adjacent islands including Palawan and the Sulu archipelago at the time of conquest or colonization, and their descendants whether mixed or of full blood, including their spouses. 3030. Thus, the concept of Bangsamoro, as defined in this strand of the Moad, includes not only Moros as traditionally understood even by Muslims, 3131, but all indigenous peoples of Mindanao and its adjacent islands. The Moad adds that the freedom of choice of indigenous peoples shall be respected. What this freedom of choice consists in has not been specifically defined. The Moad proceeds to refer to the Bangsamoro homeland, the ownership of which is vested exclusively in the Bangsamoro people by virtue of their prior rights of occupation. 3232, both parties to the Moad acknowledge that ancestral domain does not form part of the public domain. 3333. The Bangsamoro people are acknowledged as having the right to self-governance, which right is said to be rooted on ancestral territoriality exercised originally under the suzerain authority of their sultanates and the Patapangampong Kurano. The sultanates were described as states or Kairojan, Kadoctuan, resembling a body politic endowed with all the elements of a nation-state in the modern sense. 3434. The Moad thus grounds the right to self-governance of the Bangsamoro people on the past suzerain authority of the sultanates. As gathered, the territory defined as the Bangsamoro homeland was ruled by several sultanates and, specifically in the case of the Maranao, by the Patapangampong Kurano, a confederation of independent principalities, Pangampong, each ruled by datus and sultans, none of whom was supreme over the others. 3535. The Moad goes on to describe the Bangsamoro people as the first nation with defined territory and with a system of government having entered into treaties of amity and commerce with foreign nations. The term First Nation is of Canadian origin, referring to the indigenous peoples of that territory, particularly those known as Indians. In Canada, each of these indigenous peoples is equally entitled to be called First Nation, hence, all of them are usually described collectively by the plural First Nations. 3636. To that extent, the Moad, by identifying the Bangsamoro people as the First Nation, suggesting its exclusive entitlement to that designation, departs from the Canadian usage of the term. The Moad then mentions for the first time the Bangsamoro juridical entity, BJE, to which it grants the authority and jurisdiction over the ancestral domain and ancestral lands of the Bangsamoro. 3737. B. Territory. The territory of the Bangsamoro homeland is described as the land mass as well as the maritime, terrestrial, fluvial and alluvial domains, including the aerial domain and the atmospheric space above it, embracing the Mindanao-Sulu-Palawan geographic region. 3838. More specifically, the core of the BJE is defined as the present geographic area of the arm, thus constituting the following areas: Lanao del Sur, Maguindanao, Sulu, Toy-Toy, Basilan, and Mayrai City. Significantly, this core also includes certain municipalities of Lanao del Norte that voted for inclusion in the ARM in the 2001 plebiscite. 3939. Outside of this core, the BJE is to cover other provinces, cities, municipalities and barangays, which are grouped into two categories, Category A and Category B. Each of these areas is to be subjected to a plebiscite to be held on different dates, years apart from each other. Thus, categorial areas are to be subjected to a plebiscite not later than 12 months following the signing of the Moad. 4040. Category B areas, also called Special Intervention Areas, on the other hand, are to be subjected to a plebiscite 25 years from the signing of a separate agreement, the Comprehensive Compact. 4141. The parties to the Moad stipulate that the BJE shall have jurisdiction over all natural resources within its internal waters, defined as extending 15 kilometers from the coastline of the BJE area. 4242, that the BJE shall also have territorial waters, which shall stretch beyond the BJE internal waters up to the baselines of the Republic of the Philippines, RP, southeast and southwest of mainland Mindanao, and that within these territorial waters, the BJE and the central government, used interchangeably with RP, shall exercise joint jurisdiction, authority and management over all natural resources. 4343. Notably, The jurisdiction over the internal waters is not similarly described as joint. The MOAD further provides for the sharing of minerals on the territorial waters between the central government and the BJE, in favor of the latter, through production sharing and economic cooperation agreement. 44-44. The activities which the parties are allowed to conduct on the territorial waters are enumerated, among which are the exploration and utilization of natural resources, regulation of shipping and fishing activities, and the enforcement of police and safety measures. 45-45. There is no similar provision on the sharing of minerals and allowed activities with respect to the internal waters of the BJE. C. Resources. The MOAD states that the BJE is free to enter into any economic cooperation and trade relations with foreign countries and shall have the option to establish trade missions in those countries. Such relationships and understandings, however, are not to include aggression against the GRP. The BJE may also enter into environmental cooperation agreements. 46-46. The external defense of the BJE is to remain the duty and obligation of the central government. The central government is also bound to take necessary steps to ensure the BJE's participation in international meetings and events like those of the ASEAN and the specialized agencies of the UN. The BJE is to be entitled to participate in Philippine official missions and delegations for the negotiation of border agreements or protocols for environmental protection and equitable sharing of incomes and revenues involving the bodies of water adjacent to or between the islands forming part of the ancestral domain. 47-47. With regard to the right of exploring for, producing, and obtaining all potential sources of energy, petroleum, fossil fuel, mineral oil and natural gas, the jurisdiction and control thereon is to be vested in the BJE as the party having control within its territorial jurisdiction. This right carries the proviso that, in times of national emergency, when public interest so requires, the central government may, for a fixed period and under reasonable terms as may be agreed upon by both parties, assume or direct the operation of such resources. 48-48. The sharing between the central government and the BJE of total production pertaining to natural resources is to be 75 hours 25 minutes in favor of the BJE. 49-49. The MOAD provides that legitimate grievances of the Bangsamoro people arising from any unjust dispossession of their territorial and proprietary rights, customary land tenures, or their marginalization shall be acknowledged. Whenever restoration is no longer possible, reparation is to be in such form as mutually determined by the parties. 50-50. The BJE may modify or cancel the forest concessions, timber licenses, contracts or agreements, mining concessions, mineral production and sharing agreements, MPSA, industrial forest management agreements, IFMA, and other land tenure instruments granted by the Philippine government, including those issued by the present arm. 51-51. D. Governance. The MOAD binds the parties to invite a multinational third party to observe and monitor the implementation of the Comprehensive Compact. This compact is to embody the details for the effective enforcement and the mechanisms and modalities for the actual implementation of the MOAD. The MOAD explicitly provides that the participation of the third party shall not in any way affect the status of the relationship between the central government and the BJE. 52-52. The associative relationship between the central government and the BJE. The MOAD describes the relationship of the central government and the BJE as associative, characterized by shared authority and responsibility. And it states that the structure of governance is to be based on executive, legislative, judicial, and administrative institutions with defined powers and functions in the Comprehensive Compact. The MOAD provides that its provisions requiring amendments to the existing legal framework shall take effect upon signing of the Comprehensive Compact and upon effecting the aforesaid amendments, with due regard to the non-derogation of prior agreements and within the stipulated time frame to be contained in the Comprehensive Compact. As will be discussed later, much of the present controversy hangs on the legality of this provision. the BJE is granted the power to build, develop and maintain its own institutions inclusive of civil service, electoral, financial and banking, education, legislation, legal, economic, police and internal security force, judicial system and correctional institutions, the details of which shall be discussed in the negotiation of the Comprehensive Compact. As stated early on, the MOAD was set to be signed on August 5, 2008 by Rodolfo Garcia and Mohag Ricbal, chairpersons of the peace negotiating panels of the GRP and the MILF, respectively. Notably, the penultimate paragraph of the MOAD identifies the signatories as the representatives of the parties, meaning the GRP and MILF themselves, and not merely of the negotiating panels. 53-53. In addition, the signature page of the MOAD states that it is witnessed by Datuk Othman bin Abdrazak, Special Advisor to the Prime Minister of Malaysia, endorsed by Ambassador Syed El-Misri, Advisor to Organization of the Islamic Conference, OIC, Secretary-General and Special Envoy for Peace Process in Southern Philippines, and signed in the presence of Dr. Albert G. Romulo, Secretary of Foreign Affairs of RP and Dato Seri Utama Dr. Rais bin Yatim, Minister of Foreign Affairs, Malaysia, all of whom were scheduled to sign the agreement last August 5, 2008. Annexed to the MOAD are two documents containing the respective lists cum maps of the provinces, municipalities, and barangays under categories A and B earlier mentioned in the discussion on the Strand on Territory. 4. Procedural issues. A. Ripeness. The power of judicial review is limited to actual cases or controversies. 54-54. Courts decline to issue advisory opinions or to resolve hypothetical or feigned problems, or mere academic questions. 55-55. The limitation of the power of judicial review to actual cases and controversies defines the role assigned to the judiciary in a tripartite allocation of power, to assure that the courts will not intrude into areas committed to the other branches of government. 56-56. An actual case or controversy involves a conflict of legal rights, an assertion of opposite legal claims, susceptible of judicial resolution as distinguished from a hypothetical or abstract difference or dispute. There must be a contrariety of legal rights that can be interpreted and enforced on the basis of existing law and jurisprudence. 57-57. The court can decide the constitutionality of an act or treaty only when a proper case between opposing parties is submitted for judicial determination. 58-58. Related to the requirement of an actual case or controversy is the requirement of ripeness. A question is ripe for adjudication when the act being challenged has had a direct adverse effect on the individual challenging it. 59-59. For a case to be considered ripe for adjudication, it is a prerequisite that something had then been accomplished or performed by either branch before a court may come into the picture. 60-60. And the petitioner must allege the existence of an immediate or threatened injury to itself as a result of the challenged action. 61-61. He must show that he has sustained or is immediately in danger of sustaining some direct injury as a result of the act complained of. 62-62. The Solicitor General argues that there is no justiciable controversy that is ripe for judicial review in the present petitions, reasoning that the unsigned MOAD is simply a list of consensus points subject to further negotiations and legislative enactments as well as constitutional processes aimed at attaining a final peaceful agreement. Simply put, the MOAD remains to be a proposal that does not automatically create legally demandable rights and obligations until the list of operative acts required have been duly complied with. XXX. XXXX. In the cases at bar, it is respectfully submitted that this honorable court has no authority to pass upon issues based on hypothetical or feigned constitutional problems or interests with no concrete basis. Considering the preliminary character of the MOAD, there are no concrete acts that could possibly violate petitioners' and interveners' rights since the acts complained of are mere contemplated steps toward the formulation of a final peace agreement. Plainly, petitioners' and interveners' perceived injury, if at all, is merely imaginary and illusory apart from being unfounded and based on mere conjectures. Underscoring supplied. The Solicitor General cites 6363, the following provisions of the MOAD. Territory. XXXX. 2. Toward this end, the parties enter into the following stipulations. XXXX. D. Without derogating from the requirements of prior agreements, the government stipulates to conduct and deliver, using all possible legal measures, within 12 months following the signing of the MOAD, a plebiscite covering the areas as enumerated in the list and depicted in the map as category attached herein, the Annex. The Annex constitutes an integral part of this framework agreement. Toward this end, the parties shall endeavor to complete the negotiations and resolve all outstanding issues on the Comprehensive Compact within 15 months from the signing of the MOAD. XXXX. Governance. XXXX. 7. The parties agree that mechanisms and modalities for the actual implementation of this MOAD shall be spelt out in the Comprehensive Compact to mutually take such steps to enable it to occur effectively. Any provisions of the MOAD requiring amendments to the existing legal framework shall come into force upon the signing of a Comprehensive Compact and upon effecting the necessary changes to the legal framework with due regard to non-derogation of prior agreements and within the stipulated time frame to be contained in the Comprehensive Compact. 6464, underscoring supplied. The Solicitor General's arguments fail to persuade. Concrete acts under the MOAD are not necessary to render the present controversy ripe. In Pimentel Jr. v. Aguirre, 6565, this court held. XXX, by the mere enactment of the questioned law or the approval of the challenged action, the dispute is said to have ripened into a judicial controversy even without any other overt act. Indeed, even a singular violation of the Constitution and/or the law is enough to awaken judicial duty. XXXX. By the same token, when an act of the President, who in our constitutional scheme is a co-equal of Congress, is seriously alleged to have infringed the Constitution and the laws, XXX settling the dispute becomes the duty and the responsibility of the courts. 6666. In Santa Fe Independent School District v. Doe, 6767, the United States Supreme Court held that the challenge to the constitutionality of the school's policy allowing student-led prayers and speeches before games was ripe for adjudication, even if no public prayer had yet been led under the policy, because the policy was being challenged as unconstitutional on its face. 6868. That the law or act in question is not yet effective does not negate ripeness. For example, in New York v. United States, 6969, decided in 1992, the United States Supreme Court held that the action by the state of New York challenging the provisions of the Low-Level Radioactive Waste Policy Act was ripe for adjudication even if the questioned provision was not to take effect until January 1, 1996, because the parties agreed that New York had to take immediate action to avoid the provision's consequences. 7070. The present petitions pray for certiorari, 7171, prohibition, and mandamus. Certiorari and prohibition are remedies granted by law when any tribunal, board or officer has acted, in the case of certiorari, or is proceeding, in the case of prohibition, without or in excess of its jurisdiction or with grave abuse of discretion amounting to lack or excessive jurisdiction. 7272. Mandamus is a remedy granted by law when any tribunal, corporation, board, officer or person unlawfully neglects the performance of an act which the law specifically enjoins as a duty resulting from an office, trust, or station, or unlawfully excludes another from the use or enjoyment of a right or office to which such other is entitled. 7373. Certiorari, mandamus and prohibition are appropriate remedies to raise constitutional issues and to review and/or prohibit, nullify, when proper, acts of legislative and executive officials. 7474. The authority of the GRP negotiating panel is defined by Executive Order No. 3, EO No. 3, issued on February 28, 2001. 7575. The said executive order requires that the government's policy framework for peace, including the systematic approach in the administrative structure for carrying out the comprehensive peace process XXX be governed by this executive order. 7676. The present petitions allege that respondents GRP panel and PAP Esperon drafted the terms of the MOAD without consulting the local government units or communities affected, nor informing them of the proceedings. As will be discussed in greater detail later, such omission, by itself, constitutes a departure by respondents from their mandate under EO No. 3. Furthermore, the petitions allege that the provisions of the MOAD violate the Constitution. The MOAD provides that any provisions of the MOAD requiring amendments to the existing legal framework shall come into force upon the signing of a comprehensive compact and upon effecting the necessary changes to the legal framework, implying an amendment of the Constitution to accommodate the MOAD. This stipulation, in effect, guaranteed to the MILF the amendment of the Constitution. Such act constitutes another violation of its authority. Again, these points will be discussed in more detail later. As the petitions allege acts or omissions on the part of respondent that exceed their authority, by violating their duties under EO No. 3 and the provisions of the Constitution and statutes, the petitions make a prima facie case for certiorari, prohibition, and mandamus, and an actual case or controversy ripe for adjudication exists. When an act of a branch of government is seriously alleged to have infringed the Constitution, it becomes not only the right but in fact the duty of the judiciary to settle the dispute. 7777. B. Locus standi. For a party to have locus standi, one must allege such a personal stake in the outcome of the controversy as to assure that concrete adverseness which sharpens the presentation of issues upon which the court so largely depends for illumination of difficult constitutional questions. 7878. Because constitutional cases are often public actions in which the relief sought is likely to affect other persons, a preliminary question frequently arises as to this interest in the constitutional question raised. 7979. When suing as a citizen, the person complaining must allege that he has been or is about to be denied some right or privilege to which he is lawfully entitled or that he is about to be subjected to some burdens or penalties by reason of the statute or act complained of. 8080. When the issue concerns a public right, it is sufficient that the petitioner is a citizen and has an interest in the execution of the laws. 8181. For a taxpayer, one is allowed to sue where there is an assertion that public funds are illegally dispersed or deflected to an illegal purpose, or that there is a wastage of public funds through the enforcement of an invalid or unconstitutional law. 8282. The court retains discretion whether or not to allow a taxpayer's suit. 8383. In the case of a legislator or member of Congress, an act of the executive that injures the institution of Congress causes a derivative but nonetheless substantial injury that can be questioned by legislators. A member of the House of Representatives has standing to maintain inviolate the prerogatives, powers and privileges vested by the Constitution in his office. 8484. An organization may be granted standing to assert the rights of its members. 8585. But the mere invocation by the Integrated Bar of the Philippines or any member of the legal profession of the duty to preserve the rule of law does not suffice to clothe it with standing. 8686. As regards a local government unit, LGU, it can seek relief in order to protect or vindicate an interest of its own, and of the other LGUs. 8787. Interveners, meanwhile, may be given legal standing upon showing of facts that satisfy the requirements of the law authorizing intervention. 8888, such as a legal interest in the matter in litigation, or in the success of either of the parties. In any case, the court has discretion to relax the procedural technicality on locus standi, given the liberal attitude it has exercised, highlighted in the case of David v. Macapagal Arroyo, 8989. Where technicalities of procedure were brushed aside, the constitutional issues raised being of paramount public interest or of transcendental importance deserving the attention of the court in view of their seriousness, novelty and weight as precedents. 9090. The court's forbearing stance on locus standi on issues involving constitutional issues has for its purpose the protection of fundamental rights. In not a few cases, the court, in keeping with its duty under the Constitution to determine whether the other branches of government have kept themselves within the limits of the Constitution and the laws and have not abused the discretion given them, has brushed aside technical rules of procedure. 9191. In the petitions at bar, Petitioners Province of North Cotabato, Gr. Number 183591, Province of Zamboanga del Norte, Gr. Number 183951, City of Iligan, Gr. Number 183893, and City of Zamboanga, Gr. Number 183752, and Petitioners in Intervention Province of Sultan Kudarat, City of Isabela and Municipality of Linamon have locus standi in view of the direct and substantial injury that they, as LGUs, would suffer as their territories, whether in whole or in part, are to be included in the intended domain of the BJE. These petitioners allege that they did not vote for their inclusion in the arm which would be expanded to form the BJE territory. Petitioners' legal standing is thus beyond doubt. In Gr. Number 183962, petitioners Ernesto Maceda, Jojo Marbine and Aquilino Pimentel III would have no standing as citizens and taxpayers for their failure to specify that they would be denied some right or privilege or there would be wastage of public funds. The fact that they are a former senator, an incumbent mayor of Makati City, and a resident of Cagayan de Oro, respectively, is of no consequence. Considering their invocation of the transcendental importance of the issues at hand, however, the court grants them standing. Interveners Franklin Drillon and Adelto Mano, in alleging their standing as taxpayers, assert that government funds would be expended for the conduct of an illegal and unconstitutional plebiscite to delineate the BJE territory. On that score alone, they can be given legal standing. Their allegation that the issues involved in these petitions are of undeniable transcendental importance clothes them with added basis for their personality to intervene in these petitions. With regard to Senator Manuel Roxas, his standing is premised on his being a member of the Senate and a citizen to enforce compliance by respondents of the public's constitutional right to be informed of the MOAD, as well as on a genuine legal interest in the matter in litigation, or in the success or failure of either of the parties. He thus possesses the requisite standing as an intervener. With respect to interveners Rui Elias Lopez, as a former congressman of the 3rd District of Davao City, a taxpayer and a member of the Bagobo tribe, Carlo B. Gomez, et al., as members of the IBP Palawan chapter, citizens and taxpayers, Marino Ridao, as taxpayer, resident and member of the Sangguniang Panlungsod of Cotabato City, and Quezon Bucani, as taxpayer. They failed to allege any proper legal interest in the present petitions. Just the same, the court exercises its discretion to relax the procedural technicality on locus standi given the paramount public interest in the issues at hand. Intervening respondents Muslim Multisectoral Movement for Peace and Development, an advocacy group for justice and the attainment of peace and prosperity in Muslim Mindanao, and Muslim Legal Assistance Foundation Incorporated, a non-government organization of Muslim lawyers, allege that they stand to be benefited or prejudiced, as the case may be, in the resolution of the petitions concerning the MOAD, and praise for the denial of the petitions on the grounds therein stated. Such legal interest suffices to clothe them with standing. B. Mootness. Respondents insist that the present petitions have been rendered moot with the satisfaction of all the reliefs prayed for by petitioners and the subsequent pronouncement of the Executive Secretary that, and no matter what the Supreme Court ultimately decides, the government will not sign the MO. 9292. In lending credence to this policy decision, the Solicitor General points out that the President had already disbanded the GRP Peace Panel. 9393. In David v. Macapagal Arroyo, 9494, this court held that the moot and academic principle not being a magical formula that automatically dissuades courts in resolving a case, it will decide cases, otherwise moot and academic, if it finds that, a. there is a grave violation of the Constitution, 9595, b. the situation is of exceptional character and paramount public interest is involved, 9696, c. The constitutional issue raised requires formulation of controlling principles to guide the bench, the bar, and the public, 97-97, and d. The case is capable of repetition yet evading review, 98-98. Another exclusionary circumstance that may be considered is where there is a voluntary cessation of the activity complained of by the defendant or doer. Thus, once a suit is filed and the doer voluntarily ceases the challenged conduct, it does not automatically deprive the tribunal of power to hear and determine the case and does not render the case moot, especially when the plaintiff seeks damages or prays for injunctive relief against the possible recurrence of the violation. 99-99. The present petitions fall squarely into these exceptions to thus thrust them into the domain of judicial review. The grounds cited above in David are just as applicable in the present cases as they were, not only in David, but also in Province of Batangas v. Romulo 100 and Manalo v. Calderon 101, where the court similarly decided them on the merits, supervening events that would ordinarily have rendered the same moot notwithstanding. Petitions not mooted. Contrary then to the asseverations of respondents, the non-signing of the MOAD and the eventual dissolution of the GRP peace panel did not moot the present petitions. It bears emphasis that the signing of the MOAD did not push through due to the court's issuance of a temporary restraining order. Contrary to respondents' position, the MOAD cannot be considered a mere list of consensus points, especially given its nomenclature, the need to have it signed or initialed by all the parties concerned on August 5, 2008, and the far-reaching constitutional implications of these consensus points, foremost of which is the creation of the BJE. In fact, as what will, in the main, be discussed, there is a commitment on the part of respondents to amend and effect necessary changes to the existing legal framework for certain provisions of the MOAD to take effect. Consequently, the present petitions are not confined to the terms and provisions of the MOAD, but to other ongoing and future negotiations and agreements necessary for its realization. The petitions have not, therefore, been rendered moot and academic simply by the public disclosure of the MOAD, 100-102, the manifestation that it will not be signed, as well as the disbanding of the GRP panel notwithstanding. Petitions are imbued with paramount public interest. There is no gainsaying that the petitions are imbued with paramount public interest, involving a significant part of the country's territory and the wide-ranging political modifications of affected LGUs. The assertion that the MOAD is subject to further legal enactments, including possible constitutional amendments, more than ever provides impetus for the court to formulate controlling principles to guide the bench, the bar, the public and, in this case, the government and its negotiating entity. Respondents cite Supplico v. Nada, et al. 103-103, where the court did not pontificate on issues which no longer legitimately constitute an actual case or controversy, as this will do more harm than good to the nation as a whole. The present petitions must be differentiated from Supplico. Primarily, in Supplico, what was assailed and eventually cancelled was a standalone government procurement contract for a national broadband network involving a one-time contractual relation between two parties, the government and a private foreign corporation. As the issues therein involved specific government procurement policies and standard principles on contracts, the majority opinion in Supplico found nothing exceptional therein, the factual circumstances being peculiar only to the transactions and parties involved in the controversy. The MOAD is part of a series of agreements. In the present controversy, the MOAD is a significant part of a series of agreements necessary to carry out the Tripoli Agreement 2001. The MOAD, which dwells on the ancestral domain aspect of said Tripoli Agreement, is the third such component to be undertaken following the implementation of the security aspect in August 2001 and the humanitarian, rehabilitation and development aspect in May 2002. Accordingly, even if the Executive Secretary, in his memorandum of August 28, 2008 to the Solicitor General, has stated that no matter what the Supreme Court ultimately decides, the government will not sign the MOAD, Moodness will not set in light of the terms of the Tripoli Agreement 2001.